Now, the stage is all set for a supreme legal battle that will determine Kenya's political step. The Supreme Court is in the next 2 hours set to hold a pre-trial hearing for the petitions challenging the October 26th presidential election. Attorney General Githu Muigai and Third Way Alliance Party leader Ekuru Aukot have applied to be enjoined in the case. The pre-trial will set the ground rules of engagement ahead of the full hearing in a matter that must be decided by Monday next week. All right, so that's one of the top stories that we're focusing on. I now want to bring in my colleague, Murimi Mwangi. Murimi, good morning. So what comparisons can you draw from this petition, the two petitions this time round, and the one in the August 8th election?
Well, good morning, Reggie. Quite some differences here in terms of who are the parties that have petitioned the outcome of the repeat presidential poll. In August 8th, or in the aftermath of the August 8th elections, the petitioners were NASA presidential candidate Raila Odinga and his running mate Kalonzo Musyoka. But this is a different context where two activists are the petitioners in one of the petition, as well as former Kilome MP Harun Mwau, who is the petitioner in the other petition. And of course, interestingly, this time there's also a third petition that is not contesting the outcome of the repeat presidential poll, but largely seeking the punishment of opposition leaders for alleged electoral offenses emanating from their election boycott call. But besides that, perhaps you could say the context out here at the Supreme Court is not very different from what we saw in the earlier petition in terms of security officers having been deployed here to enhance security. Entrance to the Supreme Court also limited to those that have accreditation, and not very far from where we are, you can see the police barriers, the barricades that we saw the earlier time are also present here, meaning City Hall Way has been locked down at two different spots on your way to the National Archives and not very far from the County Assembly. And the same case applies to Wabera Street, yet another barricade just behind where we are standing now. A chilly morning, perhaps in reflection of the chilly political context under which the Supreme Court begins hearing these three petitions. Today is the turn for the parties to, of course, attend the status conference. This is where the court will set the ground rules in terms of who gets to participate in that petition, in terms of who will be the interested parties, who is the friend of court, commonly known as the amicus curiae. And of course, there will be discussion about how much time each of the parties will be allocated, who will be the lead counsel for the key parties in these petitions. Remember, by yesterday, Third Way Alliance presidential candidate Dr. Ekuru Aukot had, of course, applied to be enjoined as an interested party, and perhaps reading from his application for enjoinment, he said that he hopes to help the court understand the issues surrounding what happens when a candidate withdraws, and of course the question about whether there ought to have been fresh nomination of candidates before the repeat poll. For the Friends of Court, you only have Attorney General Professor Githu Muigai, and Professor Muigai will be critical to dissect into that question, because if you remember, in 2013, it was Professor Muigai who moved to the Supreme Court with a question about what constitutes a repeat presidential election ordered by the Supreme Court, and what would happen where any of the parties withdraws. And you can see some of the legal teams arriving here, and we hope that perhaps in the coming few hours, as we wait for that status conference at 11, you'll get to perhaps know what direction it will be taking. But of course, besides that, we also expect to get to know if Dr. Aukot will be admitted as the interested party. Same case applies to the admission of Professor Muigai as an amicus curiae. But besides that, is, of course, what you might say decreased momentum or what you could call political interest in the litigation process that will be happening at the Supreme Court, judging from the number of parties that have applied to either be enjoined as interested parties or as amicus curiae. You remember the Law Society of Kenya had applied last time to be enjoined as an interested party. In fact, the bench had to limit the extent to which they would participate in the petition. This time round, LSK says they won't be enjoining themselves in the petition as an interested party. I spoke to the president of LSK just yesterday, Mr. Isaac Okero. In fact, he was on his way for a conference in Entebbe, and he said that part of the reason why they wouldn't be enjoining themselves in the present litigation is that they made their contribution in the earlier petition by opposition leader Raila Odinga. Interestingly, Betty, the petition here happens in very what you call fluid political circumstances, because remember, the opposition has said they won't cease pushing for their electoral reforms and constitutional reforms through their alternative mechanisms, including the people's assemblies, as well as mass action, and of course the boycott calls against specific products, even as the court process continues here. If you remember last time, for some time, the opposition seized their street demonstrations awaiting the outcome of the Supreme Court, which ultimately was in their favor, which was the nullification of President Uhuru Kenyatta's re-election that occasioned the October 26th repeat presidential poll, which Odinga withdrew from, citing the failure by the IEBC to conduct electoral reforms ahead of that repeat poll. So interesting times for Kenya, interesting times for Africa, and the spotlight will yet again be at the Supreme Court to see what other precedent they will be setting this time round. Betty.
Interesting, and as you put it, really interesting times ahead for Kenya. And one lawyer said that this is another time for Kenya to actually build its jurisprudence when it comes to electoral matters. But Murimi, just before I let you go, let's also discuss some of the reactions and statements that have been made by various parties. On one hand, you have Jubilee lawyers, or the lawyers representing President Uhuru Kenyatta, saying that the petitioner, NASA is using other petitioners, as their surrogates and mouthpieces. Talk to us more about that. Why did they come to this particular conclusion? And NASA, on the other hand, said that they don't have anything to do with this particular petition this time round.
Well, Jubilee's argument might have emanated from previous litigations that we have seen at the High Court, the Court of Appeal, and the Supreme Court. But for the record, the petitioners, the two activists, are Mr. Njonjo Mue and Helef Khalifa. You remember, Helef Khalifa was one of the parties in a petition that set a precedent on the finality of presidential results that are announced at the constituency level. That petition, of course, had the backing of the National Super Alliance, and of course the other petition is by former Kilome MP Mr. Harun Mwau. Perhaps the presumption from Jubilee that this has the backing of the opposition is that he had been elected on an opposition inclined ticket when he was a member of parliament. But besides that, the opposition coalition itself has said that from their decision to withdraw from the repeat election 16 days to October 26th, they did not participate in the election, and they have just filed their papers here at the Supreme Court since they have been listed as respondents in some of these petitions. One of the most critical petitions where we will be seeking to see what input NASA will be putting across is that petition by the Institute for Democratic Governance, which is seeking culpability on not only Odinga and Musyoka, but also key NASA Supremos as Musalia Mudavadi and Senior Counsel James Orengo, claiming that these were the faces behind the boycott call, which according to the petitioner was an incitement to their residents not to participate in the repeat election. It will be interesting to see particularly how the Supreme Court handles that matter, because NASA has said that particular petition is not a presidential election petition, because from the basis upon which it has been filed, it's not challenging the outcome of an election per se, but seeking, the culpability for alleged electoral offenses. So interesting times for the Supreme Court, Betty.
All right. And what time is it set to start, Murimi, before I let you go?
Well, the status conference is set for 11 a.m. That, of course, could stretch to a few minutes later, judging from the tradition we have seen. But we'll be waiting to see exactly what